everyone, and thank you for joining us for today's session, where we will be looking at reporting on title. My name is Stephen Smith, and as always, I'm delighted to be joined by Ian Quayle and my colleague Robert Kelly.
Thanks, Stephen, and thanks everyone for coming along today. I was just talking to Stephen before we started about how crazy work is at the moment. And, every time we look at the sort of the SDLT holiday finishing and thinking, great, what a relief, we'll get back to some form of normality. It seems that it's just as manic as ever, which is interesting, but difficult for conveyancing. So I do appreciate the time that you're taking out to listen today. It is much appreciated. We will deal with questions at the end. So there is a chat facility which Stephen will monitor. And again, feel free to fire questions either at Stephen or Robert or myself. If they are directed to me, either send them to me or to Stewart Title. They'll pass them on to me and I'll endeavour to respond when I can. So what do I want to do today? I want to talk about reports on title, to look at some of the detail relating to reports on title, but also to talk about the bigger picture. The reason that I think this is significant is that over recent months, a number of firms have been asking me questions about reports on title. What do we do? What do we include? What don't we include? And there's a sort of constant battle, isn't there, about do we have to put in everything that we find out about the property to protect ourselves, knowing that the client isn't going to read it or understand it? Do we provide the client with a sort of snapshot of the key issues that we've identified and then generate some vulnerability on the basis that what happens if there's something that we've been made aware of that we haven't disclosed to the client? So we're going to talk about that battle and how we deal with it. And we're also going to talk about what we do relating to the report on title itself. On the sort of bigger picture point, before I sort of delve into the notes, again, just a word of caution that professional indemnity insurers are telling me that one of the areas that they're really worried about with regard to negligence claims is the transmission of information to clients and the level of understanding that clients have relating to that information. So the issue here really is not the fact that we're not doing or completing the appropriate processes as far as conveyancing is required relating to due diligence, but we're not transmitting what we find to the client effectively. So again, we'll cover that, and it is a problem. I mean, one of the things I'm often asked about is, should I be providing interim reports on title during the due diligence stage, or is it better to leave it until I've got all the information collated and then produce one or singing or dancing report on title for the client? If I'm sort of pressed on the matter, I would probably suggest, being the coward that I am, that what you do is produce interim reports during the life of the transaction in a readable format, a relatively short format, so the client has the opportunity to read and digest information as and when the transaction is moving forward, and then producing a report on title, what I would class as an old-fashioned form of report on title, before exchange, explaining all the information that has been gleaned over the due diligence process in one document. But we'll talk about that in a little more detail as we progress. So we're talking about reporting on title, key issues for conveyancers, and there are lots and lots of key issues with regard to conveyancers. The main theme and thrust of today I've already mentioned, but also about what we are required to report to clients. What should we explain to clients? And again, this ties in with lots of things that we've discussed in the past with regards to issues associated with our instructions, with regards to the steps that we're going to take relating to due diligence, with regard to the potential gaps relating to due diligence and what can happen relating to those gaps. We're going to talk about some of the issues, some of the data that will be available to us, not directly from due diligence, but from the client, and how we incorporate that into the report on title as well. Websites, again, Property Litigation Association website, very useful. City of London Law Society has a model form of commercial report on title that is quite useful as a framework for residential conveyancers as well as commercial property lawyers. And again, I bleat on constantly about the RICS website and the Consumer Guide to Surveys and Valuations. Important that our report on title incorporates some of the information that is produced in a survey, but also our client is aware of potential weaknesses of certain types of survey and valuations that are obtained by clients, normally on the basis that what's cheapest, not necessarily what's going to be the most informative. So again, Rather than explain to clients the various choices of survey or valuation, I point out to the client the consumer guide that the RICS has generated, and always recommend to a client on receipt of instructions on a purchase that the client obtains the best possible survey they can afford, and explain why. When we're looking at a report on title, we do need to think how it's structured. In other words, are we producing something for our benefit to save our souls, as it were, with regard to professional negligence claims, or are we driving the deal forward and providing the client with meaningful information? And the way it is structured potentially impacts on whether or not we achieve either or both of those things. So what I think we should be doing when we're looking at a report on title is, first of all, identifying client objective, highlighting in the report what the client's objective is, and then potentially producing some form of summary in the commercial report on title, an executive summary, highlighting what we've found that really impacts on that objective. So I'm your client, I've instructed you in connection with the purchase of a property in suburbia. I'm going to work from home, so I've told you about that. I want to construct a home office, I've told you about that. I'm concerned about car parking on the basis that I and my partner, her child, has a car each, and also there will be people visiting me that will have cars. So those issues might be significant and might be pertinent to the objective that I have relating to acquisition. In a summary, what we might do is highlight to the client, highlight to me, what we've found out about those particular issues, and then go into the report in its sort of fullest extent. We could do that on the basis of interim reports as well, and highlight at the start of the interim report client objective, and then refer the client to what we've found at that particular stage of the due diligence process. We need to explain to clients our role, and here what we've got to do is we've got to be realistic so that the client understands what we're doing, obviously, and the point again I labour constantly, what we're not going to do. The limitations of the due diligence process, the limitations relating to the fee that we are charging, the limitations with regard to our expertise. More on that in a moment or two. Should we be providing advice? Yes. Should we be providing explanation with regard to procedure, with regard to documentation? Definitely. Now, let me just allay one or two fears for a moment or two. Firstly, it is wrong to assume that a report on title is a standard document for each and every client that we act for. We should be tempering the report and the information within it to tailor our clients' needs and requirements, or to tailor it to our clients' needs and requirements. In other words, if I've got a first-time buyer, there may be information in the report on title with regard to process and procedure that we wouldn't provide for an experienced client. We may be acting for vulnerable clients, the elderly, or clients that are concerned about particular features of the transaction, perhaps who are risk averse. And again, our report on title, the advice and explanation that we provide should be slightly different. So the report on title itself will be a framework, it will be a structure. But then what we're saying within it, we need to tailor to meet client need and client requirement. So with regard to the provision of advice, certain types of client will require emphasis on different areas of advice and different explanation to others. Remember, again, a point that I think is so important, there isn't such a thing as a collective client. So the report on title should be provided to co-owners, not just one of them. We need to ensure that the report or interim report that we provide to clients is read and understood. And again, there we've got a pretty hopeless task, haven't we? How on earth can I ensure that a client has read the content of an interim report or final report and understood it? And the answer to the question I've just posed is you can't. But what you can do is protect yourself by telling the client that you are assuming the client has read and understood the information that's being provided within the report, unless the client tells you to the contrary. So it's for the client, it's for me to say, hey, I don't understand that point you're making about a restrictive covenant that prevents trade or business activity in the premises. How does that impact on what I intend to do? or there's an issue with regard to access relating to car parking, etc., that might impact on visitors that could be attending the property that I'm purchasing, attending to see me in connection with business activity. So advice and explanation needs to be tailored. As far as the report is concerned, there are lots of different potential formats that we can use. As far as our role is concerned, we're not, generally speaking, expected to advise our client about the commerciality of the transaction, whether this is a good or bad deal with regard to the transaction, but a word of caution. In the notes, there are cases that highlight if a deal is particularly bad, if information comes across our desk that is significant with regard to whether this deal is a good or bad deal, then we should be coming off the fence and saying to the client, hey, you need some advice with regard to this. Let me give you an example. Let's assume that we're buying this property at £460,000. We have another transaction in the same locality, similar property, and the property is being bought at £340,000. Well, again, in those circumstances, there may be a perfectly logical reason why there is this differential. But if we're aware of it, provided we're not breaching any client confidentiality with regard to other transactions, we can say to the client, look, perhaps you need to have a surveyor or valuer just having a look at this, because it seems a bit odd that a similar property in a similar locality is going for significantly less than you're willing to pay. And again, as far as the issue of advice is concerned, the peculiarities of the client could mean that sort of advice is required relating to whether this is a good deal or a bad deal. The best examples that I can give you of that are cases that I've been looking at recently, where lawyers have been advising clients on sort of sale and leaseback transactions in the context of residential property, or in the context of sort of equity release transactions. And some of the deals are so bad, so uneconomically unviable for the client, that the courts are saying you should be coming off the fence here, Mr. Conveyancer or Mrs. Conveyancer, and say to the client, look, this is a bad deal. You know, get some advice about this, get a financial advisor to have a look at it, have a look at the marketplace to see if there are not better deals or more sensible deals, given what you're wanting to do or needing to do. In the notes, I've mentioned at page 3 onwards some interesting comments from judges that highlight this point about advice and explanation and about our role. And that's quite interesting and quite useful. And I'd ask you to have a look at it if you have a minute or so to do so. But in short, what I'm saying is there is a duty to advise. There are circumstances where we should be advising on the commerciality of the transaction. There is also a duty to explain procedure, documentation, and indeed the work that we do. As far as the duty to explain is concerned, there are cases, County Personnel and Pulver, Balogun and Boys Sutton, that explain that it isn't enough to provide the client with a copy of a conveyance, or a copy of a transfer, or a contract, or a search result, or a report. It is necessary for us to consider the information within that documentation and to provide an explanation to the client relating to it. I would always say that we're going to provide the client with a translation of the information that's in the report, in the search, or in the document. And again, I highlight in the notes, where there is provision that's vague or ambiguous or unclear, we should be saying to our client, we need to ask the surveyor for clarification. We need to ask a builder that's provided estimates relating to repairs to clarify the work that is intended to be done with regard to those estimates or quotations. So it's not enough, again, just simply to act as a postbox. We've got to be providing our client with an explanation relating to documentation. I'm going to just mention a point here, however, that I think is important. With regard to searches, the courts have said, as a transactional property lawyer, the obligation to give advice in connection with planning issues or other quite specialist issues that arise as a consequence of adverse entries is not imposed on the conveyancer. So you're not expected to be an expert planner, an expert with regard to environmental issues, an expert with regard to valuation issues. Not at all. The key is that you're telling the client that you've identified something, you're not sure about the consequences of the significance of the something that you found, and the client should be seeking specialist advice from someone, or you should be pointing the client in the direction of where they should be looking in connection with that advice. So as far as structure is concerned, let's just have a look at this. I think we should have client objective at the start. We should have a summary of issues that we've identified that are relevant to that objective. We should be telling the client what the report on title does, what our due diligence exercise generates, and what it doesn't. We can't limit liability in a residential report on title in the same way that we can in connection with a commercial report on title. But we can emphasize to the client the limitations within which our due diligence is being performed. And I think the other thing that we can do is we can tailor the report. Again, if you look at some of the advice from professional indemnity insurers, what they're saying is standardization, case management systems, software that enable us to sort of generate and populate reports on title, create problems and issues on the basis that we're not taking into account the individual circumstances of the client. And again, that's why I think it's important that we focus in on client objective and make sure that we're tailoring the report to meet that objective or meet the needs of the client or the expectations of the client. Important point this, we're not general advisors, we're not project managing this purchase or the sale. As far as a report on title is concerned, we're not giving advice on matters of business, on the commerciality of the transaction. We are, however, to bear in mind that there could be issues that do warrant, as I've labelled a little earlier, do warrant the need for us to get off the fence and say to the client, look, I think this is a bad deal, or you need specialist advice with regard to valuation, etc. Can we use interim reports? I think we can. What about a final report? If we're producing interim reports, can we dispense with the need for a final report? I don't think we can. The report on title is a review of legal documentation relating to the target property, but I think it does a bit more than that. Why? Because I think we should be taking into account things that our client tells us with regard to the property. I think we should be ensuring that we consider the estate agent's particulars, survey and valuation, and any other reports or documents that our client has had commissioned courtesy of purchase. We need to think about the entire picture. So whilst it is a review of legal documentation, it is in fact a review of the due diligence process that has been performed by a buyer and a buyer's conveyancer. So it goes beyond simply looking at the documentation and saying, here's what we found and here's what we've got. I repeat the point that I made as far as interim reports are concerned. I think they're a good idea, provided that the client is provided with a final report that brings together the interim reports that have been submitted during the conveyancing process. Just before I leave this slide, there's another important point to note. Let's assume that you're acting on a purchase. You're about to exchange contracts. You've produced a report on title for the client. Just because we then exchange does not mean that if other information is drawn to our attention, there is no need for that information to be dispatched to the client. There is quite a raft of case law where solicitors have been sued in negligence, having produced a report on title for a client, having exchanged contracts, and then having had additional information provided to them that hasn't been transmitted to the client. Now, of course, such information is unlikely to enable the client to escape the liability that's created by the exchange, but it might do. So a report on title isn't a sort of one hit and then we don't have to worry about things any further. It is a constantly evolving document up until the production of the final report and exchange of contract, but it might be necessary to impart knowledge to our buyer client after exchange that has come to our attention. So there may be documents that are provided after exchange that the client needs to be aware of. There might be some missing information that should have been produced before exchange is produced after exchange, the client is still entitled to see it, and we are still obliged to assist and give advice relating to it. So, important considerations. Client objective we've mentioned. Appropriate due diligence. What is appropriate due diligence? Talk about that in more detail in a moment or two. Limiting the scope of the retainer. To do that, we're going to tell the client the scope of the due diligence process, the limitations relating to that process. And the report does a number of things. It targets data and information to the client objective. It reveals what has been undertaken with regard to the due diligence process and what hasn't been undertaken if the report is properly prepared. And it enables the client to form a decision as to whether or not they wish to proceed relating to the transaction. And here, of course, we touch on those magic words, informed consent. A client cannot authorize you to effect a lawful exchange of contract unless they understand what an exchange of contract is, and unless they understand the significance of the exchange and the fact that they are bound by the information that has been revealed courtesy of your performing due diligence, and also what is revealed by survey valuation and indeed client inspection. And I think if there's one point that I want to get over this morning, it's that when we are preparing a report on title, we shouldn't just simply focus in on the information that has been created courtesy of what we've done. We should be asking clients to report to us after they've inspected target property, because there may be issues that are revealed by that inspection that are significant and need to be included in the report. I think in emphasizing to the client the need to inspect and to report to us what they find, we do two things. One, we achieve the task that I've just examined, but secondly, we also heighten the client awareness of the significance of their inspection of the property. So how else, other than disclosure by the seller, are we going to be aware of overriding interests? How else, other than disclosure by the seller, are we going to be aware of third-party interests, third-party occupants? How else are we going to be aware of a potential problem, other than via disclosure by the seller, of sort of boundary movement or boundary dispute? So all the considerations I think on slide here are very important. We've got to be aware of the fact that the report is doing two things: protecting us and providing information, meaningful information, to the client. Should we provide a summary? I think we should. I think it's a good idea just to highlight things that we find that are particularly pertinent to this client. I think it is important, if we provide a summary, that we emphasize that there could be other information in our interim reports or final reports that are just as significant and just as important. I don't want the client simply being lazy and looking at the summary and saying, right, that's it. And I think we've got to make sure that our client reads all the information that we produce. But at the same time, the provision of a summary will focus in on key issues and will also enable us to refer to other documents, refer to other findings that within our interim reports or final report that can provide detail. A summary should identify areas of weakness within the due diligence process or the information that's being provided. I think that's important, that the client understands that the due diligence process, the work that we've done, is not sort of fail-safe, and that there could be issues or problems relating to it. Again, going back to one of my common mantras, setting realistic client expectation. When we're explaining things to clients, what does the case law reveal? What do professional indemnity insurers tell us in connection with reports on title? Well, they tell us a number of things. Firstly, to avoid legalese, the obvious. Secondly, to make sure that clients understand precisely what we're doing. And to that extent, we should be telling the client what we're not doing. We're not going to be inspecting the property that our client is buying in normal circumstances. The searches that we undertake have limitations. There could be information that becomes in the public domain after we've performed due diligence, in which case, in a lot of circumstances, we're not going to be revisiting our searches or the information that we've got, unless the client highlights an issue or we become aware of an issue that warrants further investigation. So case law reveals, professional indemnity insurers report reveals that what we need to be doing is explaining to the client the conveyancing process, the information that has been revealed to us, and the limitations relating to it. As far as explanation is concerned, if we're sending to our client an 80-page report on title, bet your life the client isn't going to read it. Bet your life your client is not going to understand it. And therefore, what is the point? The point of producing an 80-page report on title is so that we can say to a court or to our professional indemnity insurer or to solicitors that are later acting on the sale, your client, our client, the claimant was aware of the position. We told them about this. The danger is that a court says, well, you can't really expect a client to trawl through the massive information that you've produced and identify those particular points or that particular point. I think a summary helps us. And I think that's why sort of interim reports are potentially more useful, in that we're giving clients bite-sized pieces of information. There's another point as well that I think is useful and worth mentioning here. Remember the wealth of material that is out there with regard to the conveyancing process, with regard to land registration, with regard to issues associated with plans and boundaries, a lot of which I've shared with you over the last sort of 18 months, 2 years or so. But for those of you that are relatively new to these webinars, have a look at property protocols, the boundary dispute protocol, and information with regard to what is needed to identify a legal boundary. If we're dealing with leasehold properties, have a look at the Leasehold Advisory Service website, the Leasehold Knowledge Partnership website, the Association of Residential Managing Agents website, and there is a wealth of information about the conveyancing process, about particular aspects of the conveyancing process, and in connection with the two latter websites, information about leasehold ownership. And remember, when I speak to people about residential leasehold transactions, we get fixated with the lease, and these are the provisions within the lease, and we don't frequently think about the bigger picture, explaining to the client the peculiarities of a landlord-leaseholder relationship. So we can cut down our report on title. We can ensure that clients have better understanding by using resources that are out there that sort of make the same point, but in a different way. So again, I think that the idea of the report on title should be that we're providing the client with this big picture, but at the same time, there are other resources that we can use to supplement and support what we're saying. I go back to the SRA and Law Society thematic review of leasehold conveyancing, 2017, where the SRA and Law Society was saying, clients don't understand the distinct disadvantage they face courtesy of becoming a leaseholder rather than the freeholder. And that's an important point that should be explained to clients buying leasehold property. And again, if we're going into that level of detail in a report on title, we're into our 80, 90 pages of data. Why not refer to some of the advice that's available on the Leasehold Advisory Service, Leasehold Knowledge Partnership, that explains the bigger picture about leasehold ownership and the relationship of freeholder and leaseholder, or landlord and leaseholder. Our report on title needs to explain the searches that have been undertaken. Again, it might be a good idea to reiterate to the client the searches that were available and to highlight the fact that there are searches that are mandatory, courtesy of the conveyancing process, and there are other searches that are appropriate given locality, given client objective, but there are other searches that are available that have not been done. So the client understands, and again, I would explain this right at the start of the transaction, all the searches that are available, the searches that have been done, and the fact that there are other searches that are available. So local search and additional inquiries. Let's deal with this very swiftly. One, property specific and out of date the moment it's done. Does client understand that? Where a local search and additional inquiries of local authority revealed adverse entries, do we highlight those adverse entries and report to the client what should be done in connection with getting additional information? So, something I frequently latch onto as an example, tree preservation order. Local search, additional inquiries reveals a tree preservation order in connection with a birch tree in the garden. Okay, well, all right, you tell me about that as a lay client, fine. You should be telling me about the consequences or potential consequences of that tree preservation order. I can't lop, I can't fell. I may have to undertake sort of management work with regard to the tree to keep it in good order. And if I don't, there are fairly significant fines and the potential for criminal liability arising. With regard to planning, if there's enforcement action, if there's an issue with regard to a development plan in the locality, you don't have to be a planning expert and tell me as the lay client about the intricacies of the planning regulations, law, and about the significance or consequences of what the search reveals. You've just got to tell me that it may be appropriate to get advice from a planning consultant, or it may be necessary to undertake additional research or work with regard to the adverse entries that have been identified. Drainage and water searches, again, explain to the client the limitations relating to those searches. Environmental searches, we should always be advising any client of any residential or indeed commercial property of the benefit of an environmental search and report. We should read the report, but we should not advise upon it. And again, explain to the client that we're probably not qualified or experienced enough to be able to give advice, but that an environmental consultant or surveyor could give advice in connection with the content of the report. With regard to searches, the key is, these are the searches that we've done. This is what the searches reveal. These are the limitations relating to searches. If there are adverse entries or issues relevant to client objective, this is what we can do or you can do to clarify the position, to pin down what we've found, to reduce or remove your potential vulnerability. So the report on title should explain the searches, explain search results, highlight adverse entries, recommend further action. Again, there's an issue here. What is the position if you're telling me as a lay client that you've found an issue with regard to, I don't know, a coal mining search? So there's evidence of subsidence, or there's evidence that there's an old mine shaft, a drift mine in the garden, or something of that nature. So you tell me about that. How far do you have to go with regard to your recommendations relating to further inquiries, etc.? Well, the point there is you draw to my attention the issue that you've identified, you make a recommendation as to what can be done relating to finding out additional information with regard to the adverse entry, and explain to me the risks associated with that adverse entry. Now, is it going to impact on my ownership of the property? Could it impact on valuation? Could it impact on the potential sale of the property as and when I come to sell? Certainly, if I've got a client that takes a cavalier attitude with regard to an adverse entry, I'd be very careful about recording the client's attitude and repeating my advice with regard to additional steps that can be taken to try and determine the potential liability or vulnerability that arises. What I don't want is a situation where I've highlighted a problem, the client in essence has sort of laughed it off and said, well, not a problem, I'm happy to proceed. Client then finding on acquisition that he's got a major problem, or when he comes to sell or refinance, he's got a major problem, and then start to point the finger at me. I've got a report on title that says, hey, I've highlighted this, but I haven't necessarily recorded the follow-up communication relating to what's been identified. So I'd always be careful about that. And again, you know, when we're dealing with a situation where we're presenting the client with potentially bad news, we've got to be careful. What I suggest is we present the bad news, but then suggest solutions or suggest methods in which we can sort of limit the potential vulnerability or liability that could arise. Other searches, our report should highlight the fact that what searches are available, should highlight the limitation related to the searches that we've done, highlight the fact that it may be necessary to do additional searches or to update searches, depending on circumstances. On that latter point, local land charges that are migrating to the land registry, if you get an official search, you can update the search, I think, for a period of 6 months without charge. And I know a lot of the search providers carry facility whereby it's a relatively simple task to update searches. And of course, Robert, not forgetting that there are products in the marketplace, which you may be able to tell us about, that enable searches in essence to be protected courtesy of indemnity. Robert?
Yes, Ian, that's true.
Yeah.
We offer search validation policies which can be used to update a search which is up to 2 years old. So where you've got a situation where there's a long delay between your initial searches and exchange and or completion, the policy can be obtained there quickly and cheaply and will effectively redate that search as at the date of the policy.
And that policy will indemnify loss relating to any adverse entry. Is that how it would work?
That's right. Any changes in the search, any adverse entries which would have been made apparent if you'd done the search at the date of the policy will be covered in the same way as if you'd got a full search at that date.
Thank you. So again, there are things that can be done to protect the client and, more significantly, protect yourself relating to searches, as Robert's just identified, a policy there that really is just as much benefit to you as a conveyancer as it is to the client. Environmental searches, again, there's some staggering data out there about how much land in England and Wales is contaminated. We've talked about that before when we've talked about land contamination issues. But it's pretty scary stuff, to be honest with you. Environmental searches and reports are necessary. Clients should always be advised about the potential vulnerability for decontamination on land acquisition, or indeed on taking a tenancy of land. It is important that clients understand what your role is with regard to an environmental search. In essence, you're a messenger and providing the client with the search and report, explaining to the client that if there are any issues arising, specialist advice is required relating to it. So a report on title, although this isn't a title issue, should highlight the fact that a report, an environmental search and report is being undertaken, provide the client with a copy of it. I would read it, but make sure that the client understands that you can't give any advice relating to it. Why do I suggest you read it? Just in case there's anything there that is so glaringly obvious that you can warn the client about it. I'm minded a few years ago of a firm that I did some consultancy work for, and what they were saying was that they were telling clients that they wouldn't read environmental searches, wouldn't read surveys or valuations, just basically making sure that clients were aware that they wouldn't read them on the basis that they couldn't advise upon them. I think that's dangerous, particularly with regard to surveys and valuations, but also with regard to other reports or searches that are undertaken on the basis that there might just be something there that is relevant to you as a transactional property lawyer, or is worthy of your intervening and telling the client, look, I've read this and there's something there that I don't understand or I'm not sure about. Now, again, where we're working on the basis of fixed fees, we can limit our retainer and make sure the client is aware, particularly with regard to an environmental search, that we won't be reading it at all. But surveys and valuations are different issues completely. Contract. In a report on title, should you be telling the client about the contract? Should you be drafting 16 or 17 pages going through each and every standard condition and explaining the client the significance of that condition, which will apply to them on exchange? The good news is that isn't necessary. I've toyed with this over the years because the Law Society used to produce guidance notes on residential conditions of sale, but in essence were sort of quite quiet, client friendly. It isn't necessary to do that. It is, however, necessary to explain to the client the significance of the contract, the significance of signing the contract, and of course the significance of effecting an exchange of contract. We do need to report to the client any variations to the contract, and some of the key features of the contract, namely purchase price, namely interest rate, penalty rate, namely issues with regard to fixtures, fittings and contents, also special conditions with regard to persons in occupation, etc., etc. But I am not, for the life of me, saying that we need to trawl through the conditions and produce a whole raft of explanation of each and every condition that applies. The only ones that I think are significant are issues with regard to buyer insurance, issues with regard to deemed knowledge relating to inspection. Plans. Again, the number of times I see reports on title accompanied by a land registry title plan, and the report referring to the fact that the property is revealed by the title plan shown edge red. Again, sorry, it's a broken record. A title plan does not reveal a legal boundary, does not reveal the legal extent of the property that's being acquired. It is a guide and it is an indicator of what the land registry contend may be the extent of the registered title. So I think what we should be doing in our report on title is giving the client a copy of a title plan with a health warning. In addition to that, we should be saying to the client, we've got a description of the property as per the contract, as per the property register, as per the estate agent's particulars, as per survey and valuation. In the report on title, if there are glaring inconsistencies between all those resources, we should tell the client that there are inconsistencies, and we should also be reminding our client of the fact that we've given the client all that information prior to their inspection of the property, and we've asked the client to confirm to us or refer to us if the documentation that the client has seen relevant to the description of the property is inconsistent with what they see when they inspect. So I'm not saying you can't, in the report on title, include or refer to a land registry title plan. I think it's a good idea to, provided the client understands, and you drill this point home, that although this appears to be an official looking plan produced by the land registry, its reliability is questionable, and that the client should not be using it to determine the extent of the property that is being acquired. Now, I'll repeat the point that I made earlier. Survey, estate agent's particulars, description of property in the contract, description of property in the property register, all of those things should be provided to the client, probably before the client sees or is given a copy of the report on title. I would arm the client with that data and information right at the start of the transaction when I receive contract bundle and when survey and valuation is to hand, and saying to the client, inspect and check that the documentation is consistent with each other and is also consistent with what you see. My report on title will simply highlight that the client has inspected and hasn't revealed to us that there appears to be any inconsistencies between the documentation and plans that have been produced and what they've seen. And our job is, again, just to check the data and information that we hold on file as part of due diligence, when we can confirm to the client in our report that there doesn't seem to be any inconsistency between description in the documentation that we've got on our file. Again, with regard to plans, I highlight a number of points, and this last point on this slide is so important. The courts are constantly bleating that plans may not be accurate, are dangerous as sources of information relating to the physical extent of a legal title. Just been doing some work with regard to a determined boundary application at the land registry. A case called Witten Woodhead is the case from memory. And again, interestingly, there was a plan and a description of a boundary, and the description of the boundary referred to wooden stakes. The wooden stakes that had been put in the ground to reveal the boundary were, I think they were 2 inches or 3 inches wide, and the dispute between the parties was so minute, the area of land that was disputed between the parties was so minute that the court, it was the county court judge that was dealing with this matter in a first tier tribunal, sorry, upper tribunal, was saying, well, we need to know precisely where the legal boundary is. And to do that, we need to know which side of the stake the parties have determined is the boundary. Is it the east side of the stake, or is it 4 inches further to the west on the basis it's the western side of the stake? So again, that just shows you how difficult it is to identify a legal boundary. And the moment we start putting a red line, black line, or indeed any other coloured line you care to imagine on a plan, we're not really doing ourselves or our clients any favours. It is description, national grid coordinates, that is really going to assist us where we've got boundary sensitivity. Remember what I said before I bored you all to death at the start today? Client objective. Identify client objective. In doing that, we can ascertain if there's a boundary sensitivity issue. There is a boundary sensitivity issue because I'm your client and I'm telling you that I'm going to demolish the existing garage that's on my property and build a new double garage as close as I can to the western boundary. You in the report on title need to be warning me in your summary, given my plan or objective with regard to the site, that the conveyancing process is not going to enable me to identify the legal boundary, thus is not going to enable me to know that where I should be building my extension, meaning that I may be trespassing onto a neighbour's property, or meaning that I may in fact be building my extension, my garage, whatever, within my land, leaving a gap between the boundary, wall or fence of the garage and the actual boundary or true legal boundary. Leasehold titles and reports on title. Again, careful. Important point this, an absolute leasehold title is not necessarily a good and marketable leasehold title. Watch the property register. There may be a warning in the property register that the land registry has not seen a consent relevant to the superior title out of which the lease is derived. Also, with regard to leasehold titles where we're producing a report on title, don't forget to think about the superior title out of which the lease is derived. And again, just check for issues such as restrictive covenants, etc., that could impact on your client's ownership. Now, you're going to say to me, Ian, this doesn't really matter, because if there's a problem with regard to the superior title, I can always advise my client to bring an action against the landlord for derogation from grant, assuming there's a restrictive covenant that my client is breaching relevant to the superior title, but there isn't a breach relevant to the leasehold title. Well, the point there is, yeah, you can bring a derogation from grant claim, but it's going to be a claim for damages, which isn't really going to be satisfactory for your client, given the fact your client wants to live in the flat or apartment that they've just bought. So leasehold titles, in the report on title, think about the superior title out of which the lease is derived. And also in the report on title, think about the point that I made about the peculiarities of the relationship between landlord and leaseholder. And again, in my report, I wouldn't be providing the information that the SRA and Law Society require you to provide. What I'd be doing is referring or highlighting to the client to additional resource, either printing off the guidance that the Leasehold Advisory Service provides relating to leasehold ownership, or the Association of Residential Managing Agents guidance about leasehold ownership, and referring to it in the report on title and advising the client that it ought to be read. If I can just move on. Overriding interest in the report on title. Is it necessary to explain to a client in a report on title what an overriding interest is? Answer yes. Why? Because your client is your eyes and ears with regard to inspecting target property and determining the existence of overriding interests. So I've seen some reports on title where lawyers are saying to their client, we haven't inspected the property, and therefore there may be overriding interests that are binding on you as a buyer that we and you are not aware of. I would turn that on its head, and I would say in my report on title, I would be saying to a client, you need to be aware of the fact that there are overriding interests that aren't recorded on the title, that would not necessarily be disclosed to us by the seller, and that the only way of becoming aware of those overriding interests is courtesy of your inspecting target property and reporting to us anything that you appear to regard as suspicious. To that end, you've got to tell clients what overriding interests are, give the clients examples of overriding interests, and highlight the fact that the client is under an obligation to you to tell you about anything they see. The client should, to that end, then be told about the fact that the client will have constructive notice of any overriding interest that would be obvious on inspection had they undertaken a reasonable inspection, as well as being or having notice of anything that they actually see or anything that is imputed to them, courtesy of a third party acting on the buyer's behalf, seeing the existence of something that could amount to an overriding interest. So overriding interests worry me. They worry me because I think as a conveyancer, I could simply take the easy option and say, I'm not going to be aware of anything that is an overriding interest unless the seller tells me about it. I think we've got to do more than that and warn the client about the fact that these interests are binding on them and highlight to the client that it is the client's inspection that is potentially going to reveal the existence of an overriding interest, and where the client does reveal an overriding interest, of course, mention it to the client in the report. I would also refer the client to the fact that if there is an overriding interest that exists, there is an obligation on you and the buyer client to notify the land registry utilising land registry form DI on registration of the disposition at a later date after completion. Overriding interests do worry me due to the fact that frequently as a conveyancer, we're looking at procedural issues and overriding interests are frequently overlooked given the standard sort of due diligence processes that we undertake. And to an extent, we're entirely reliant on what the seller discloses to us with regard to their existence. Buyer client needs to be aware of the fact that it is their inspection that is going to reveal to us any overriding interests that have not been disclosed by the seller. I mentioned earlier in my presentation the continuing obligation to advise before completion. I'll give you some case law on the slide, some of which is referred to in the notes that you need to be aware of. In essence, highlighting the fact that where there are things that are discovered or disclosed after exchange, after the report on title, but before completion, it is an obligation on us as the buyer's conveyancer to disclose what we see. Neighbour and Barker, the reason that the court held that this was so significant is that there was a problem with regard to completion. And had the buyer been fully informed as to the fact there was information that hadn't been disclosed to him revealing structural defects, that non-disclosure would have given him an opportunity to dispute completion and perhaps give a reason not to complete. And again, McManus Developments in Barbridge, similar thing there. Disclosure of the movement of a fence line. Again, solicitors acting for the buyer failing to disclose the position to the client generated a whole raft of issues, namely further investigation of the seller's conveyancer, advice to the buyer client about the position. There were steps that could have been taken to alleviate or rectify what became a problem. And Mercantile Building Society against Mitchell and Dodds, so professional negligence claim brought by a lender. Again, report on title to the lender, lender not having all the information that was necessarily available to enable them to determine whether or not the property was good security or otherwise. So all of these cases sort of fire a warning shot about the dangers of simply saying, right, we've produced our report on title, we don't have to worry anymore. I think one of the things that's interesting about looking at the conveyancing process, doing training with regard to the conveyancing process is that it is not a series of steps that are sort of individual steps. You've got to look all the time at the process, client objective, and whether there are issues relevant to that objective. And you've also got to look at the cumulative effect of information that is disclosed as part of due diligence. So there could be planning issues and a restrictive covenant that are both pertinent to the same point. Again, in a report on title, it would be important to refer to the fact, well, you know, what you're proposing to do is going to be a breach of planning permission, and is also going to be a breach of restrictive covenants. Or where you've got a situation where a client is contemplating variation or removal of restrictive covenant courtesy of a Section 84 application of the Law Property Act 1925 to upper tribunal, you might have a situation where planning permission is being granted for that use, or planning applications have been submitted and planning permission refused, which could have significance with regard to that Section 84 application. As we touched on in the past, property fraud. You know, you can't just simply onboard a client, undertake your procedures and processes to verify ID, and then think, right, I don't have to worry about property fraud throughout the transaction. You've got to be aware of it throughout. And again, looking at a report from a professional indemnity insurer, that's one of the things that is highlighted. The fact that there could be professional negligence in a conveyancing transaction that arises due to a number of omissions or errors that are made in the conveyancing process, not just one failure or omission at one particular stage of the process. Conclusions. Lots of information and notes about reports on title. Have a look at the City of London Law Society's commercial report on title. It's quite interesting as a structure. Have a think about interim reports on title and a final report. Have a think about effective communication. Are there things that we can do better rather than simply bombarding the client with lots and lots of documents? Bad habits. One, there's the search result, have a look at it. There's a contract, read it. That's not good in any way, shape or form. There's the contract. These are the key things you need to be aware of. There's a search result. These are the adverse entries that we need to investigate further. There's a copy of the charges register. There's a copy of the relevant notice, and there's some information about the interest in land to which the notice relates. To avoid negligence claims, to get things right, you do the simple things well. Making sure we're communicating effectively, making sure we have evidence on our file that confirms we've asked clients if they've understood. We've invited questions from the client and they haven't generated any questions. These are the important things. Stephen, I'm conscious of time. I'm conscious of question time. So can I close at that? I've put Robert's contact details on slide there, my details as well. If you have any requirements for product, then Robert and Stephen and their team are available to assist. And of course, their website contains a wealth of information relating to online applications. And they have a team of very bright young underwriters that are willing and able to talk about bespoke products, etc. So again, Stephen, if I may, feel free, anyone that has any particular product requirement, to speak to Robert or Stephen or any members of the team. If there are any questions relevant to what I've been discussing, feel free to drop me a note or to put them in the chat box now. Stephen, have we got many questions?
Yes, we have actually. Thanks, Ian, and thanks for mentioning the team there and the service we offer. That's very kind of you. So yeah, we're now going to begin answering some questions today. We have had a few questions in, and as a reminder to everyone else, you can still submit questions through the questions panel in your attendee control panel. We have got a few questions in already, so we may not get to them in this session, but we will, if you want to send something to Ian or myself, we will try and respond after the webinar today. So in the first question is from Brian. He asks, if a flat lease term is short, say 71 years remaining, but buyer is a first-time cash buyer, and you warn him of all the dangers of accepting it and the massive premium likely to extend in future for either a mortgage or a sale, would it be sufficient for the lawyer to allow the buyer to proceed subject to him giving you a waiver?
Yeah, it would. No harm in that at all. I mean, often that sort of transaction is nice when you've warned the client, you're comfortable that the warning has been effective. The client is an experienced client and understands. Fine. The only thing that Brian has mentioned there that would worry me is the fact the client is a first-time buyer. I think you said, Steve.
That's correct. Yes.
So where I had a first-time buyer, I'd be saying to the client, look, you might have this sort of cavalier attitude with regard to this purchase, but I'm warning you that when you come to sell, there will be a problem, and where you come to wish to extend, as you are likely to during your ownership, then there will be a significant penalty with regard to premium that's paid. So I would be happy to act for a first-time buyer in that situation, but I would be ensuring that I'd be sending an email or hard copy letter to the client, giving them the warning. And the other thing, Brian, I'd want the client to sign it. In addition to a waiver, I'd want the client to acknowledge the communication that I've sent to him or her with the advice. So I'd have a waiver and I'd have an acknowledgement of the email that I've given, warning the client that whilst he may be quite prepared to proceed, I'm telling him that a reasonable buyer at a later date would not be willing to proceed. And the only way that a sale could properly proceed would be for the client that Brian is acting for to pay the premium and extend the lease. So, the easy thing, Brian, is just to walk away and say, I can't act. You can act, be perfectly reasonable to act, as long as you've warned the client, and given he's a first-time buyer and therefore potentially inexperienced, I would sort of have a safety net. So waiver, letter of advice, client signing letter of advice. I understand this. I fully appreciate the risks and vulnerabilities. And in my letter or email, I'd say what the vulnerability is. And if he's done that, I'd be happy to proceed. Great question, Brian. Thank you.
Yeah, perfect. Thanks, Brian. And thanks, Ian, for that. Brian did come back about 10 minutes after that, actually, separate issue, a comment stroke question. Yeah. We'll do the break quickly. It's a comment stroke question. I don't think it'll be very difficult to answer. The point that Brian was making here is with regard to the report on title, basically, if a client is not going to read an 80-page report, are they any more likely to read a 20-page report packed with external resources available for them to read?
Yeah, I would say the more likely, there's a chance. But what I would probably do is I would make, if I was going to provide a 20-page report to the client, I would have a summary. These are the things that you need to know given your objective. The rest of this contains information that is binding on you that you need to be aware of. And I think I would leave it at that. There's no way, the point that Brian is alluding to, there's no way, no matter what we do, that we can honestly say we can guarantee the client has read that document and understood it. So all we have to do is try and make sure that we are attempting to produce information the client will read. That's why, Stephen and Brian, I like using external resources. And the other thing that, again, is quite useful, say we've got an adverse entry. Or going back to Brian's first question there, we could probably find, and I'd look at the Leasehold Advisory Service website for this, there will be examples of just how much premium someone would be obliged to pay in connection with extending a lease. Lease term is 71 years. So I'd be providing the client with examples. So, and if there was an adverse entry relating to a local search relating to planning, I would be saying to the client, look, there's an issue here. and you realise the significance of enforcement action being taken against you. And if you've got a sort of a catalogue or a library of cases where you've seen people being prosecuted for enforcement action or being required to take buildings down, etc., give the client a copy of that, because it scares the living daylights out of them.
Mm.
So I think Brian's right. There isn't a guarantee, but if we can produce a report on title, and if there are key issues in that report, and we can refer to other things or ram home to the client the significance or consequence of this, the better it is. But Brian's right. No matter what we do, there'll always be the client that there'll be the client that hasn't read the 5-line email that we've sent to them about a particular point, or the client that didn't understand the 2-paragraph email about the enforceability of a restrictive covenant, for example.
Yeah, no, of course. Thanks, Ian.
Yeah.
Question from Robert McAnally. Robert says that I'm convinced that the average client is not aware of the limitations on the solicitor's role as decided by the courts in various cases that you mentioned in the notes.
Yeah.
If these limitations are made clear to the clients, then there must be a concern that the client will view the lawyer's role in practice as being no more than an administrative role that does not warrant a significant fee. I'm sure that most law firms of solicitors dealing in real estate matters would see themselves as business advisors, not mere reporters of such search results.
Yeah.
Is this the significant difference in your view between residential and commercial property work?
Yes, it is. But the other thing that I always say about residential conveyancing is this: the mechanics of the conveyancing process are relatively simple. Okay. The skill, and why conveyancers, I think, are undervalued, is that with experience comes what I call the sniff test. I can look at a transaction, I can look at a series of circumstances and say to myself, there's something potentially naughty here. Not naughty as in fraudulent, something that's going to potentially bite the client. Or there's something that this client hasn't quite grasped, and it's the ability to spot that and help the client and hold the client's hand with regard to that point that's important. So, again, Robert mentions there about sort of commercial transactions and the use of artificial intelligence in purely commercial, not commercial property, commercial transactions. And what people are saying is, the idea of having someone trawl through a share purchase agreement looking for key clauses or issues that are unusual, that role is potentially disappearing due to artificial intelligence. The hand-holding role, the taking the client through what artificial intelligence has revealed, will increase. And I think putting that in the context of residential conveyancing, your job is to understand the client, see whether the client's risk averse, whether they're nervous, whether they're experienced or inexperienced, and hold their hand through the exercise. That leads to a problem, given what we've had during lockdown. We're not seeing clients, we're not communicating with clients as we used to, and therefore it's more difficult to get a taste or a flavour of client attitude. And I think that's one of the big issues with regard to the conveyancing process during lockdown, and as it develops, as it will be in the future. We're not going to be seeing clients. We're going to be dealing with them via email. We're going to be having meetings, probably via sort of virtual platforms, like we're doing today. And putting it bluntly, every delegate that's attended today may well be sitting with the Times newspaper and their feet up, smoking a cigar, Stephen and Robert. I don't know. And just as if I'm having a conversation with a client and the camera's not on, they might be listening to me. They might be holding on to their mobile telephone, waiting for a call from their phone company or a gas provider or something. That's the issue.
Indeed, yeah. Although I would say, I think given the end of quarter and the stamp duty issues, I think people on the call are going to be relatively busy at the moment. I would assume.
I was being facetious.
I'm sure you were. Sorry, Ian. Yeah. just actually following on, because I think this question ties in quite well, because you're talking really about the sort of the expertise or the perceived expertise around transaction, and I think that kind of ties in nicely with fees, because fees, chargeable fees, hours, that's long been a conversation, because I think with our industry, the insurance industry, there has been a sort of it's a downward pressure on pricing. So the question from Christopher is, do you have any idea in man hours how long in chargeable hours should be allocated to a report's entitle on a typical transaction, or as a percentage of the total time allocated to a job? And they follow that and said, i.e. at the start, as an estimate of the whole job.
Yeah, I would guess that to sit down and populate a framework report on title would take a conveyancer an afternoon to do it properly. If you've got case management systems, if you've got sort of issues pages in your case management system or on a paper file, depending on how you used your issues page, you might be able to reduce that significantly. Interestingly, Stephen, I'm doing work currently with someone that is trying to produce a report on title, a framework report on title that self-populates as well as having input from conveyancers. And what we're trying to do is devise a system whereby the amount of time that it takes to populate a report on title is reduced to below 30 minutes. So in other words, what will happen is the report on title will be automatically populated from data that the conveyancer can receive, and that the conveyancer's task is just really to check over key features of the report. Now, my view is that at some stage in the near future, we will get a report on title that is automatically populated with data from search companies, land registry, etc. I think that's going to happen, in which case the amount of time will be driven down dramatically. But if you were saying to me, Stephen, as just have, how long would I think it would take a conveyancer to produce a report on title without a case management system, without an issues page? Let's say 3 hours.
Yeah.
The point then becomes, can I charge for the 3 hours that I spend? And the answer to that, in most cases, probably not. With regard to fees, unfortunately, just as you were saying with the insurance industry, Steve, you know, we're sort of cutting our throats all the time, aren't we? And one of the things that I've tried to say to conveyancers is, don't buy business on the basis of price. Try and differentiate and try and, you know, produce service. And someone once told me that if you do a good job, the fees look after themselves. And I think there's a bit of that. The problem with conveyancing, however, is this, that you only really know if you've got a good conveyancer or a bad conveyancer if something goes wrong. The standard transaction, you know, you could be good, bad, or indifferent. It doesn't matter. The transaction sort of looks after itself. But it's where something goes wrong, where there's something unusual, that, you know, you're required, you know, the good conveyancer, the experienced conveyancer will come to the fore. The problem with that is that a lot of clients don't perceive that what we're doing is difficult. They perceive it as being a relatively straightforward transaction that we complicate in order to justify fees. And I think estate agents, to an extent, sort of muddy the waters or stir up the waters, if that's the right term, by, you know, blaming conveyancers for delaying, causing problems, creating issues that don't really exist. So I've gone around the doors there. Sorry about that. To answer the question, if I was said, right, as a fee earner, no case management system, no issues page, 3 hours, I would allocate to produce a report on title.
Excellent, thanks, Ian. But yes, as you say, I mean, technology is consistently improving, so I assume that will come down massively in the next few years if it's not already. And thanks, Chris, for that question. So just a few more to get through quickly. And one from Katie. Katie asks, when acting on a new build purchase, does the same advice apply to the plot plan provided by the developer as it does the title plan provided by the land registry?
Yeah, it's only the estate layout plan that is guaranteed by the land registry. So if you've got a plot that borders the edge of the development, then that boundary is guaranteed by the land registry. But the actual plots within the development are not guaranteed.
Excellent, thank you. Thanks, Ian.
If you've got a client that's buying plot, I would always say it's pegged out. Where you're really boundary sensitive, remember what I said about that case called Witten Woodhead, I would ensure that, you know, you're looking at a stake and you refer to which face of the stake is the actual boundary, not the stake itself.
Interesting. Okay, thank you, Ian. Thanks. And then final question from Mark Cairns. Well, actually, sorry, I say question. It's a clarification, I think, in a polite way, perhaps. It says, on the one hand, you're suggesting that we don't or we shouldn't advise on environmental reports, but on the other, you were saying that we shouldn't just say, here's the searches, take a look at them. Could you clarify which one it is? Or is it a nuanced position?
With regard to let's look at environmental searches and reports in isolation to start with, right? What I'm advocating is this. I would say to a client, I cannot give you any advice on the content of this report, yeah? But what I would do is read it, okay? And if there's something that's glaringly obvious a problem or glaringly obvious warranting a further investigation or further inquiry, I would tell the client. Yeah, so I'm not advising on it. I'm just saying I've read it. I'm not sure about that reference to, I don't know, lead contamination relating to the back garden, right? I'm not going to give any advice. I'm just saying the report refers to it. You need specialist advice with regard to that contamination. So I'm not going to say to a client, I've read it. I would read it, and I would, if it warranted it, refer the client to what I've read. I'm not giving advice upon it. With regard to a search, any of the searches that I'm obliged to do as part of due diligence, I would report to the client any adverse entry. But, and again, I can give Mark a good example of this. Years ago, I dealt with a client. We were buying a bus depot. And obviously, bus depots, there's diesel contamination. There's all sorts of stuff that would worry me. So we dealt with that. The report referred to Japanese knotweed. At the time, Japanese knotweed was relatively unheard of. So the client and I were discussing it, and I'm saying, well, yeah, you really need to get to grips with the diesel contamination. I didn't think anything about the Japanese knotweed at all until the night after I met with the client, when I looked it up on the early internet, and there it was, and I realized what a problem it was, and I reported it to the client and said, hey, look, there's an issue here. Today, in that situation, I would read the report. I would say to the client, if there's anything in that report that generates any potential liability, you should get some expert advice relating to that liability risk and cost of decontamination. So if I was reading that report today, if I was acting for that client today, I would say to the client, I'm not giving you any advice upon it. When the report comes in, I'd read it, and I'd say to the client, I've read that report, I've had a look at it. Have you got some expert advice with regard to the Japanese knotweed and the diesel contamination? So I hope that answers Mark's question. So what I am saying, I hope, is consistent. But environmental searches and reports, I'm particularly wary about. I'll read it. I'll tell the client that I'm not going to give any advice upon it. If there's anything in there that would warrant or justify my intervention to say you need advice, I would tell the client they should get specialist advice. Great question, Mark.
Yeah, thank you, Mark. Thank you, Ian, and thanks to everyone for submitting the questions, and to those of you that have stayed on right to the end of the presentation. today. So that's going to say thank you to everyone for attending the session. If you do have any further questions, please do contact Ian or myself. Once you leave today's webinar, you will receive an automated message from GoToWebinar. And if you respond to this email, the replies will come directly to myself, so I can send any questions or feedback on to Ian. You'll also receive a separate email from my colleague Robert Kelly, which will contain the slides and the notes to today's session. So I just leave to say, on behalf of Stewart, Title and Ian Quayle, thank you for joining us today, and have a great rest of your day. Thanks everyone. Goodbye.